In a surprising reversal, Team Justin Baldoni has dropped their subpoena request from Taylor Swift. Now, of course, Blake Lively and most of the mainstream media is jumping on this as a win towards Blake, but it's not. We need to discuss.
The story surrounding the lawsuit between Blake Lively, Wayfair Studios, and certain PR representatives is complex, but after closely examining Blake Lively's claims and cross-referencing them with available evidence, many of her allegations seem to fall apart. Some of the claims were straightforward to disprove, while others required more effort. A key turning point was a video released by Justin Boney, which showed a different version of events than how Blake described them. The video itself tells the story of how Jamie Heath met his wife, Natasha. Jamie and Justin have been longtime friends and are both practicing members of the Baha'i faith, with strong ties to their religious community. Jamie, who is now the CEO of Wayfair Studios, has an impressive resume, having recently served as a producer on It Ends With Us and as an executive producer on Scarlett Johansson's film Eleanor the Great, which premiered at Cannes. One of Blake's lawsuit claims was that when she met Justin and Jamie, they talked about how Justin had met a woman he wasn't interested in dating, so he passed her on to Jamie, implying, in Blake's framing, a crude exchange of women. She portrayed it as though Jamie was getting Justin's sloppy seconds, a depiction that felt both offensive and inaccurate. But when the actual video surfaced, it revealed a different story entirely. Justin met Natasha at a club, they danced, went for coffee, and he later invited her to church, where she eventually met Jamie. Justin and Natasha never dated. There was no romantic relationship between them. Instead, Jamie and Natasha grew closer through shared spiritual experiences. It's a genuinely touching story, especially for those who respect faith-based connections, and seeing it twisted so maliciously in a lawsuit felt deeply disheartening. This misrepresentation made me feel for the women caught in the crossfire, especially Natasha Heath and Emily Baldoni, the wives of Jamie and Justin. They now live under a cloud of public suspicion fueled by accusations that their husbands behaved inappropriately or harassed someone on set, claims that contradict who these men are by all credible accounts. Additionally, stories about Justin discussing his growth in understanding consent and boundaries were mischaracterized by Blake and her husband, Ryan Reynolds, to paint him as a predator, a serious and unjust distortion of someone's vulnerability and self-awareness. After months of reviewing the situation, I no longer believe any of Blake Lively's claims. In my opinion, her side consistently twists facts and narratives to suit their agenda. This belief was only reinforced today when I received a cease and desist letter from Stephanie Jones, whose attorney further mischaracterized lawsuits involving me, proving once again how narratives are being bent to serve a misleading and damaging storyline.
Planet, I am Andy Signor. It's been wild seeing how the press has taken this story. Now, yes, Taylor Swift will not be subpoenaed. Justin's team has backed off, but we got to talk about why and what's really happening. We also got to talk about how most of these articles are excluding one very specific comment that I think is incredibly important. Part of the reason the summons was dropped was because details that Brian Freeman, Representative Baldoni, and crew sought were provided, I hear. Now, I've been confirmed that as well. The reason this has been dropped isn't what Blake Lively's telling you out there. I want you to see what Blake Lively's attorneys were quick to declare this a win for her side now that Justin has withdrawn the subpoena sent to Taylor and her legal team after the firm objected to the amount of the unwarranted.
Stephanie Jones accused me of having a long history of being defamatory and harassing toward others, claiming that my goal is to damage businesses and reputations. That is simply not true. That has never been my goal. She pointed to the fact that I settled 2 lawsuits as proof of her claim, but the reality is far more nuanced. One of those lawsuits was dismissed in the state of Washington, and later, after multiple people on both sides threatened legal action, the matter went to private mediation. In the other case, someone sued me, and I filed a countersuit in response to what they were doing to me. Both cases were ultimately settled with no findings of liability and no money exchanged. Despite this, she said, the swift settlements of many of these matters are telling and reflect the indefensibility of your statements. That's a mischaracterization. I've always been open and transparent that no money changed hands, and no court found me to have been defamatory or harassing. To add to the irony, this same person now defends a man currently facing accusations of human trafficking in a California court. Watching what's being done to me makes it clear how easily people think they can twist narratives for their benefit. When I started reviewing the amicus curiae briefs being filed in the case, I noticed irregularities. These briefs are generally used in appellate or Supreme Court cases, not at the district court level, so there's less clarity around their timing. The appellate rules say amicus briefs should be filed within 7 days of the related brief, and I suspected that Blake Lively's legal team, including Brian Friedman, would ask the court to deny or strike these briefs for being late and irrelevant. Some people accused me of spreading misinformation when I pointed that out, but just recently, Brian Friedman sent a letter to the court that confirmed much of what I had said. In that letter, Friedman addressed the recent amicus filings by equal rights advocates, the California Employment Lawyers Association, and the Women's Law Center, who sought to support Lively's motion to dismiss the amended complaint. The motion had already been fully briefed months ago. He argued that the court should deny these organizations' request to file their untimely partisan briefs, which simply recycled Lively's arguments and served no new legal purpose. Instead, they appeared to be a tool for continuing Lively's public campaign against the Wayfair parties. Although Friedman was respectful toward the organizations themselves, he emphasized that their filings would not aid the court at this early pleading stage. If the court does allow the briefs, he requested that the Wayfair parties be granted the right to respond. Furthermore, Friedman pointed out in a footnote that the judge's individual court rules don't even list motions for leave to file an amicus brief as a motion type permitted by a letter motion. However, out of caution, the Wayfair team still filed a formal response. All of this underscores the extent to which narratives can be manipulated for strategic purposes, and how important it is to scrutinize these tactics carefully.
Fishing expedition, etc., etc. Lively's team was quick to reply with a statement and said that we are pleased that Justin and the Wayfair parties have withdrawn their harassing subpoenas to Taylor Swift and her law firm. We supported the efforts of Taylor's team to quash these inappropriate subpoenas directed to her counsel, and we will continue to stand up for any third party who is unjustly harassed or threatened in the process. Oh my God, what a big laugh. Now, the reality is why they did this, the reality of why they squashed this, they got what they wanted. Now, others have started reporting on what we alluded to when this initially broke.
The 2-day window for opposition aside, the motion to file the amicus brief should be denied because neither the motion nor the proposed brief meets the limited conditions under which a district court may consider such filings. Amicus briefs at the district court level are typically allowed only under very specific circumstances, primarily to aid the court when a party is not represented or is inadequately represented, or when the amicus has a direct interest in another case that may be impacted by the decision in the current case. None of those conditions apply here. In this instance, the amicus organizations are not providing new or necessary information beyond what Blake Lively's legal team has already presented. Their involvement is not to support an unrepresented party or to inform a broader legal issue affecting unrelated cases, but rather to bolster Lively's position, a move that appears redundant and procedurally inappropriate. Importantly, there is no inherent right to file an amicus curiae brief, especially when the applicant's only objective is to influence the court's interpretation of the law, as is the case here. The organizations do not claim that Lively's counsel is incompetent, nor do they identify any related case that would be affected by the court's decision on her motion to dismiss. Instead, they rely on their unique role as authors and advocates of California Assembly Bill 933 to argue their point. In effect, they are offering premature and inappropriate expert testimony at the pleading stage, which is not the intended function of an amicus brief. The Seventh Circuit has noted that most amicus briefs are filed by parties allied with the litigant and merely duplicate the litigant's arguments, effectively serving as an attempt to extend the length of a party's brief, an abuse of the amicus process. This filing is being portrayed as an abuse of court procedures, akin to a tactic previously objected to by Lively's own legal team when Wayfair's attorneys issued a subpoena. Just as that filing was struck for procedural reasons, this amicus brief could similarly be removed from the docket for failing to meet proper standards. Amicus curiae, by definition, is meant to be a friend of the court, not a friend of the party. While the Wayfair parties acknowledge the broader advocacy work of these organizations, in this context they are not neutral contributors, but partisan advocates aligned with Lively's legal strategy and policy interests. They cite precedent, such as Jones v. Bakura, where leave to file was denied to a partisan advocacy group because their contribution at the trial level was diminished by their lack of neutrality. Furthermore, the proposed amicus brief introduces arguments not raised by Lively herself, most notably, concerns over discovery abuse in sexual harassment cases. However, this point is moot in Blake's case, as discovery is already well underway due to her own affirmative lawsuit. Lively did not move to stay discovery, and thus arguments related to avoiding abusive discovery practices are irrelevant. The court is being asked to consider briefs that raise concerns disconnected from the actual procedural and factual status of the case, which further supports denying the motion to file.
Because I told you guys, look, I still firmly believe it, and I'm hearing it more and more through sources and people I'm talking to. There's only 3 people that this source who told Justin's team that they were extorted could be Tree, Taylor's manager publicist, or her dad, Scott, or her mom. Now, I'm leaning more towards her parents more and more. Candace Owens just went the other day and heavily implied it as well. I think we're on the same wavelength. Now, again, they haven't themselves confirmed it yet, and they may not want to, but it makes total sense, guys. You got to think about this. As Taylor Swift is now being extorted and threatened with all these text messages to come out, that doesn't help her brand at all. And she's a very powerful business with a huge fan base. I don't think they react well to bullies. I really don't. And I think this was too much for the entire empire to bear. And so it makes total sense that her parents or her manager were the ones who went out and said enough is enough. And now that they've squashed it, now, like, really think about it. Now that it's squashed, which all these outlets are trying to say, oh, no longer subpoena, no longer. Why do you think that really was? Now, this is my opinion, my conspiracy theory. It's exactly what it says right here. They got what they wanted. Now, if they have proof that Taylor's lawyer was threatened, if that's all real, that will come out in the process. And they clearly wanted it out there to send a warning shot to Blake and Ryan.
Discovery is already underway in this case, and the Wayfair parties argue that the proposed amicus brief violates the timing guidelines typically followed by district courts. While the federal rules of civil procedure do not explicitly govern amicus brief submissions, courts often refer to Rule 29 of the Federal Rules of Appellate Procedure, which states that such briefs must be filed within 7 days of the principal brief being submitted. In this instance, the organization submitted their proposed amicus brief more than 2 months after Blake Lively filed her motion to dismiss, well beyond the permissible timeframe. The Wayfair parties point out that including the brief would cause further delays, as they would need time to respond, and any delay in ruling on the motion to dismiss unnecessarily prolongs the resolution of the dispute. For this reason, they assert that the brief should be denied. The filing of this amicus brief is framed as being well-intentioned by the organizations, who likely believe they are acting in the public interest. However, their brief does not fulfill the proper purpose of aiding the court impartially. Instead, it advocates for Blake Lively's position, essentially attempting to influence the judge's interpretation of the law and support her claims, making the brief partisan, not neutral. The organizations are not offering new legal insight, but rather reasserting arguments already made in Lively's motion to dismiss. As a result, the brief does not contribute anything materially new to the court and serves only to delay proceedings further. This delay compounds an already complicated docket filled with numerous motions. These include a motion to compel filed by Leslie Sloan, a motion to quash a subpoena by Stephanie Jones regarding the forensic extraction of John Abel's phone data by Edgeworth Security, motions to dismiss from Leslie Sloan, Ryan Reynolds, and Blake Lively, third-party motions to dismiss from Stephanie Jones, third-party complaints against Jen AEL, multiple outstanding motions to compel involving Lively, and 2 motions for sanctions. Every new filing slows down the case, as the judge must address each motion before proceeding with any rulings. Many discovery-related motions may ultimately be rendered moot depending on how the court rules on the larger issues. The way the amicus briefs were framed is especially troubling because they appear to relitigate Lively's claims and paint Justin Baldoni as a malicious, abusive sexual harasser retaliating against her through litigation. This is misleading, especially since Lively's legal team already made that argument directly. Moreover, Lively is represented by a team of high-powered, well-resourced attorneys. She does not require additional assistance from outside advocacy groups to make her case. The Wayfair parties contend that these filings are being used not to serve the legal process, but to further damage them in the court of public opinion. Given how cautious the judge has been about what is entered into the docket, it seems like a strategic and respectful move on Wayfair's part to ask the court to deny the amicus brief without directly insulting the organizations behind it. As someone who has followed and covered numerous cases over the years, this is the first instance where such a tactic, using amicus briefs in a trial court setting before an appeal, is being employed. While such briefs are more common in appellate or Supreme Court cases, their use here appears to be more about public narrative and media leverage than about contributing new and necessary insight to the legal proceedings.
who think they're on the road, winning, and they're winning, but no. If they can prove that Taylor Swift's team and lawyers, in fact, confirmed or gave them the evidence to show that they were asked not to do this, oh man, Blake, you are in so much trouble. So much trouble. And I don't believe for a second that a man like Brian Friedman, who is on this like crazy, he's all about the squeeze. He applies those pressure points like I haven't seen many other lawyers do. Maybe the one, Spyro, was Jay-Z's lawyer. These are high quality lawyers who just apply the pressure when they need to. And they applied the pressure to Taylor. She responded in kind because she realized Blake's been just as a simping for Blake and Ryan. No, we're not playing that game. In fact, it's interesting. There was a Puck newsletter I wanted to share where they were talking about the extortion theory. And as even they were one of the very few, because they got good insight over there, even they were sort of acknowledging the silence was pretty deafening. Why isn't she saying anything? And so as this went on there, I want to get to the specific part as they go through all of these things. High gear. They got into an interesting part because they acknowledged she hasn't said anything, which is not normal for her. Meanwhile, the gossip industrial complex is shifting in high gear on fresh whispers of a Lively Swift falling out, and Lively's team appears acutely aware of the risk.
Some people have drawn parallels between Blake Lively's current strategy and Amber Heard's approach during her legal battle with Johnny Depp. In Heard's case, despite several advocacy groups voicing support and portraying her as a victim, she ultimately lost in court, though technically it was a split decision, as both sides were found liable for different claims. Eventually, they settled. Many still consider Heard a victim, even though the legal system didn't fully agree. The suggestion is that Lively appears to be following a similar playbook, seeking outside support through public narratives and advocacy organizations, potentially to influence perception if not the legal outcome. For those who closely followed the Depp-Heard case, these moves by Lively might feel familiar, even though the circumstances are different. That said, the Wayfair legal team has responded with focus, avoiding public spectacle while pushing back on tactics they view as partisan or unnecessary at this stage. Another notable development this week came from a report by Puck, an independent media outlet. A journalist at Puck, who allegedly has had past conflicts with Stephanie Jones, published details about Blake Lively's beauty brand, Blake Brown, indicating that the brand has suffered a dramatic decline in sales, reportedly between 56% and 78%. This decline is cited in Lively's legal filings as evidence of reputational damage stemming from the negative media attention associated with the lawsuit. Lively appears to be using these figures to claim financial damages, asserting that the legal dispute has directly harmed her brand's performance. However, Puck reports that internal sources at Target, one of the brand's key retailers, attribute the drop to other factors, specifically a fallout with Taylor Swift. According to Puck, Lively allegedly attempted to pressure or blackmail Swift into publicly supporting her, threatening to release over a decade's worth of their private text messages if Swift didn't comply. The claim reportedly came from Scott Swift, Taylor's father, who is said to have provided this information to Brian Friedman, Lively's opposing counsel. Since that story broke, neither Taylor nor her father has denied the allegations. In fact, Swift's camp reportedly responded by distancing themselves entirely. Sources close to Taylor say she wishes she had never met Lively and is cutting her out of her life. Several of Swift's close friends, including Cara Delevingne, Sophie Turner, and Gigi Hadid, are also said to have severed ties with Lively, choosing to support Taylor instead. Target insiders told Puck that Blake Brown is expected to do less than $15 million in total sales in 2025, a dramatic drop from what was once projected as a $100 million brand. The insider called Blake Brown a non-conversation at Target now, suggesting it's fallen off the radar entirely. Lively's beverage brand, Betty Booze, which is still sold on Carnival Cruises, is also said to be underperforming. As one source quoted in Puck put it, "It's ironic that one of Blake's dragons came back to bite her, just like in Game of Thrones." The implication is that the public and professional backlash from the alleged threat against Taylor Swift has had a far more devastating impact on Lively's business reputation than anything Baloney has done or claimed. This narrative undermines Lively's attempt to attribute her brand's collapse to defamation or legal retaliation by Baloney. If the real trigger for the financial downturn was her own alleged actions towards Taylor Swift, and not the lawsuit itself, her claims for damages may be much harder to prove. The shift in public support, especially the loss of backing from Swift's massive fanbase and influential friends, seems to have done significant reputational damage, arguably more so than anything stated in court.